Hi, everyone. Harry here to talk about two broad and important district court decisions, each setting aside Trump executive orders that are basically these broadsides against so-called, for them, ideological bugaboos like DEI or gender ideology. And the interesting thing about both these cases and the opinions that just issued is they are both very attuned to Supreme Court rulings from the last couple weeks. That includes the Skermeti case, which permitted a state, let's just say loosely, action involving gender identity, and more importantly, the nationwide injunction case, which said you can only provide relief in order to give complete relief to the plaintiffs and no broader. So both of these cases are aware of that. And finally, the common point is they are under the Administrative Procedures Act. So this is the kind of second sort of ingenious workaround to the Supreme Court's opinion last Friday. We talked about class actions. We've seen a few of these, and now we're talking about the Administrative Procedure Act, which permits a judge to set aside, so-called vacatur in the legal term, orders that she or he find are contrary to law or arbitrary and capricious. Okay, so to dig a little bit deeper, there are two cases. They're simultaneous, but let's take up one that is from the District of Massachusetts. And in that case, Judge Young was dealing with these very broad sort of ideological tirades against so-called DEI. And so-called matters here because after a long trial with a lot of evidence, so this is a permanent remedy that the judge is entering, subject, of course, to appeals. He found, for starters, the administration can't even say what the hell DEI means. So they cite certain parts of a circular that's consistent with the executive order, and it basically says some disparaging things about DEI, like it's amorphous and based on policy, but literally don't even single it out. He makes that as an actual finding. So when it comes time to saying, have they acted in conformity with the APA, which requires agencies not to do arbitrary and capricious actions, he says, no, this is about as arbitrary and capricious as it comes. It is really just a kind of ideological attack masquerading as law. And so he sets the whole thing aside. Now, there are certain hoops you have to jump through under the APA to do that, but he finds they've all been met. In particular, he finds that there's been so-called final agency action. You have to give them a chance to get their house in order before you actually strike something down. He finds it's been arbitrary and capricious. It's just these undefined or vague authorities. Relatedly, the APA problem that Young identifies is that you violated congressional mandates on areas of research, and that happens again and again. Congress says, fund these areas, and here's the money. And Trump comes in and says, we don't do DEI anymore, or we don't want diversity, or whatever he singles out, and then just issues an order and leaves it to the sort of bureaucrats to pluck out the offending programs. And the process, as we've heard both here, this is, by the way, a consolidated action. So it involves here, but also actions across the nation. You have just these Doge bureaucrats saying, oh, that sounds like it's got a little whiff of diversity, or that might, and there's no concerted effort, if indeed they were even able to distinguish between what remains in this country unlawful discrimination, which you can't do, and as opposed to voluntary programs that you can do, but an administration can also say you can't do, that has something to do with, say, diversity, equity, et cetera. But there's not making a clear legal line means they would actually sweep in unlawful discrimination that the law still remains and the Civil Rights Act still remains is against the law. Okay, so that's basically what Young does. The important point is he's got a trial that they went through a couple months ago, and evidence of all kinds, including the plaintiffs, who are saying, this really makes it much harder for me to do my job, and we need these programs in general, and here's the many things I now can't do. And also really zeroing in on the administration's just inability to say what the hell they're doing and what DEI means and the like. So based on that, arbitrary and capricious, and will do the vacating thing. But he, as is the case with the other judge, is focused on complete relief for the plaintiffs. So there's some of these provisions that have to do with China that the judge finds these plaintiffs here have not been hurt at all. And so talking about the nationwide injunction case, citing it expressly, saying, Supreme Court, I'm following your instructions. The judge specifically exempts from that order anything that has to do with China, which he finds just hasn't been solidly challenged and there's no real standing on. So what might have been a week ago a nationwide injunction is a very broad injunction because it's consolidated actions. It's almost everything in the order, but snipping out stuff about China. Okay. And a similar kind of legal maneuver happens in the other case, which is important in its own right as well. And that is a case in D.C. before Judge Bates. And it is brought by medical organizations and researchers challenging the HHS, which gets the executive order and then orders the administrative agency under it to restrict or just halt federal funding for reproductive health research, especially statutes involving in vitro fertilization or reproductive techniques. Just, that's out the window. And the judge here likewise said, you violated the APA when you did this. It is a final agency action, and you made this change in policy outright. You're no longer covering all these things, and you didn't give notice and comment. And the APA says you have to give notice and comment, and you didn't give a reasoned explanation, and you have to give a reasoned explanation, and you didn't consider the reliance that the plaintiffs and others have placed on these rules that you're just getting rid of in a fell swoop. So for all those reasons, you acted beyond your statutory authority, and I'm doing the vacator thing. But again, it makes clear at the end of the opinion, I'm not going beyond the orders that you've given me under the new case. But Bates is very focused. I think all district courts across the country are on this new Supreme Court opinion. So he vacates, but I can't do it all, just complete relief. So I'm going to vacate only as to the particular programs and others that have been cut out that the plaintiffs identify that they rely on. The plaintiffs come forward and say, we need this information. We look at it very quickly as we're treating patients and the like. And so that's really our basis for being here. So to remedy all those injuries, but only those injuries, and to show the Supreme Court they are saluting the opinion from last week, the vacator only goes to those actual websites and things that were on that were ordered scrubbed, that these folks rely on, and the same thing for specific grants. So again, you're having the court still very, very hostile to this arbitrarily imposed set of guidelines from Trump to cut out all this stuff, but particularly where it involves kind of cutting edge MAGA social issues like gender identity and DEI, which the administration, or Trump even on the campaign trail, says they're going after, but no one knows. It seems pretty clear what the hell they're even talking about, or tries at all to make the distinction between things they're getting at and other things that have anything to do with preventing discrimination. And so you have, in the wake of the Supreme Court decision, you have courts, and these are two important decisions doing just this and covering a very broad swath of folks and grants. The one, remember, in Massachusetts is consolidated actions from across the country saying, you haven't complied with the APA, and besides, what the hell are you even talking about with DEI? You got to be more precise. So vacating, but only as necessary in the court's judgment to provide complete relief to the plaintiffs involved. Meaning, if there's other stuff untouched, the administration can still consider it operative, or can basically try to serve it all up, maybe on the emergency docket, to the Supreme Court for that kind of shadow docket relief with all the attendant problems that we've talked about. Okay, so still district courts pushing back hard against these ideological, we don't like it kind of social practices, but hewing to Supreme Court direction of only granting relief to make these people before them whole. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.